Okay, so it's 7:01. We're going to go into our workshop for the first half hour, and then at 7:30 promptly, we'll convene our regular meeting agenda. So tonight, for our workshop, we're going to discuss, with guidance by Jennifer and our other consultants, the special use permit process, what it is, all of that good stuff. So,
all right.
Thank you, Jennifer.
So tonight we're covering special use permits, which is one of the items within your jurisdiction, along with site plan and subdivision, certificates of appropriateness, and architectural review. So special use permits are just one of the land use approvals that are within your jurisdiction. We're going to talk about what it is, what it's not, the procedure, and I have some case law examples as well. So, as I just mentioned, and I've got the PowerPoint presentation up on both screens if you want to follow along. So a special use permit, we're going to cover what it is, the procedures for reviewing a special use permit, what happens when someone needs a variance from a special use permit standard, and what to be considering in your final determinations, both reasonable conditions of the special permit and the concept of substantial evidence. So, what is a special use permit? A special use permit refers to a particular type of use that is allowed in the zoning district, subject to compliance with certain standards. So it is in your schedule of use regulations listed as a particular manner in which a particular use is authorized, but it does come with it certain standards. So it's not a use that the city council has determined can just be permitted as of right, maybe just subject to site plan approval or a building permit. It's something that it's permitted as long as it meets several conditions. And it's up to the planning board to review those conditions to make sure that the use complies, and if so, the permit is granted. Importantly, it's not a variance. A lot of times people think special permit and they think that they equate it with a variance. And a lot of times those two terms are used interchangeably, but they are very different. So unlike a variance, which gives permission to an owner to use a piece of property in a manner that's inconsistent with zoning, a special permit, again, allows somebody to use a property that's consistent with the zoning ordinance as long as it meets certain standards.
Quick question.
Yes.
Certain parcels carry special use permit requirements. Certain parcels don't. What's built into the decision-making around which might and which might not carry a special use permit requirement?
So I'm going to flip forward for a second.
Oh, am I jumping ahead?
Yeah, so here's your schedule of use regulations. I know that this is completely illegible up on the PowerPoint, but you do have access to this in E-codes in the zoning code. What this is on the left-hand side, you see all of the types of uses that are permitted by district. Yep. Then across the top is all the various zoning districts within the city. And within each of the little boxes, you have either an X, meaning the use is not permitted. You have a P, which means it's a permitted use. An SP, which means it's a special permit use permitted by the planning board, or an SP with an asterisk, meaning it's a special permit use permitted by the city council. So it's district by district and use by use. So a particular use, for example, a bed and breakfast, might be a permitted use in one district, but it might be subject to a special permit approval in another district. So you always have to look at the district that you're in. Yep. And what uses are permitted and how they're permitted in each of those districts. So this is your tool for determining that. So I hope that helped answer your question. Now let's see. Okay, there we go. All right, so you kind of covered my first topic here, list of uses. The zoning code identifies uses in each zoning district that are subject to a special permit. We just reviewed the tool in the zoning code that you can use to determine what special permit uses are permitted in your district. As far as approval authority goes, generally speaking, the legislative body, so the city council, can authorize the planning board or the zoning board to decide special use permit applications. So city council has the authority by default for special use permits, but it can delegate that authority to either the planning board or the zoning board, or it can keep it to itself. So in Beacon, as we saw in the, I didn't quite see because it's hard to read up there, but as we just discussed, in Beacon, some special permits, the planning board is the approval authority, some special permits, the city council is the approval authority. In recent years, the city council has been sort of getting away from being the approval authority for special permits. So for example, we just had, the accessory apartment, there was a special permit that just got transferred from the city council to the planning board, if I recall correctly.
Yes.
And John might remember.
Right. It used to be the city council, then it went to the planning board, and then they took it away and made it as of right use.
That's right, yeah, and that was for accessory apartments. So then, as far as procedure goes, the zoning code is going to specify exactly what procedure to follow for reviewing special permits, and that's at section 223-18 of your code. That section specifies the number of copies of the application form that needs to be, the application package that needs to be submitted by the applicant, the timing, it has to be submitted 2 weeks in advance of a meeting. It specifies public notice requirements for the application. A public hearing is required, and that's a matter of state law. So we have to require a public hearing for all special use permits. For site plan, that's not the case. For site plan, local municipalities actually have the option of requiring a public hearing or not. In Beacon, in your code, you do require a public hearing for site plan applications, but that's not the case everywhere in New York because the state enabling statute gives that option to the municipalities to decide. So that was a little tangent. 223-18 also specifies that you have to make your final decision on the special use permit application within 62 days after the public hearing is closed or after SECRA is complete. The application has to include a certificate of inspection, and that's referring to that I&I, the inflow and infiltration review that has to happen with every application, and that's in addition to the code in the past couple years or so. The city has undertaken efforts to try to identify properties that may be improperly connecting their sanitary sewer to the stormwater and make sure we're cutting that connection. And as an application comes in for a land use review, that's a good time to check that. It also explains that a special permit expires after the approval is issued if a building permit is not, building permit application is not submitted within 1 year. An applicant would have to request an extension, or the approval expires and is null and void at that point. Once a building permit is issued, the applicant then has either 1 year or 2 years to complete, depending on if it's a new building or renovation. So those are just some of the really exciting procedural aspects of the code as it relates to special permits. The other interesting thing about special permits and the procedures for the code is in 223-18, it does give the building inspector some pretty powerful authority. The building inspector can revoke a special permit if it's found that the use of the premises under that special permit doesn't conform to the conditions of the special permit. So you issue a special permit that says this use, conforms with the character of the neighborhood as long as it's operated from 8 a.m. to 5 p.m. And it's found that that use is operating consistently until 10 o'clock, 11 o'clock at night. under our code, the building inspector would have the authority to revoke that special permit. So that's a pretty powerful tool.
And that never sunsets? I'm sorry, that never sunsets, that ability to do that?
Nope, that's a
Okay.
provision in our code. That's a
Is it subject
local
to
law.
litigation? Like administrative review, or?
Sure, so any determination by the building inspector is subject to review. The first step would be an appeal to the zoning board of appeals.
Okay.
So the zoning board of appeals would hear and determine whether that revocation was proper.
Right.
And then the zoning board's decision could then get appealed in an Article 78 proceeding to Dutchess County Supreme Court.
Oh, wow.
Would that ever get sent back to the planning board? If it was a special use permit that was issued by the planning board and then was,
If the planning board's resolution specifically said that it was retaining jurisdiction and, authorized the planning, or the building inspector to bring it back to the planning board instead of revoking automatically, it would, basically, that's not addressed in the code, so unless it's addressed in the resolution, then no, unless the applicant affirmatively reapplied and sought up some sort of modification of the.
So, okay, so maybe that's part of what your question was. If an applicant wanted to reinstate or somehow
Yeah.
make good and promise never to do it again, they would need to come and reapply.
They would,
Yeah.
yeah, because at that point, there would be no special permit in effect.
Got it.
Yes.
Is there any tool to enforce compliance other than revocation? Like, is there any provision for other fines, or is it just kind of like, you have a nuclear option and that's it?
Yep, so there is, there's the justice court process, and I'd have to double check. I can't recall if in Beacon, it's a violation of the code to violate a resolution of the planning board. I think it is. I think that amendment was made in recent years, but I would have to double check. If that's in there, if there's a provision in the code that says it's a violation of the zoning chapter to violate the conditions of a planning board resolution, then the building inspector, as the enforcement authority of the zoning code, could issue an appearance ticket and a violation to appear in city court, city justice court,
And they
and
can
that's
impose a
treated
fine?
as a criminal violation.
Wow.
Um,
And the court could impose a fine?
Correct.
Yeah.
Yes. Yeah. All right.
Don't mess with Bruce.
Bruce has a lot of power here. All right, so there's the schedule of use regulations, which we talked about. All right, so here's the meat of special permits. As I mentioned, special use permits, it connotes a use that's permitted in the zoning districts as long as it meets certain uses. There are general certain requirements. There are general standards or requirements, and then there are specific standards or requirements. General standards are found at 223-18, and there's, 6 of them. And these apply to every single special use permit in the city. And we can kind of run through what they are. The first one is that the location and size of the use, the nature, the hours, and intensity of the operations involved in or conducted in connection with it, the size of the site in relation to it, and the location of the site with respect to streets giving access to it are such that it will not conflict with the appropriate and orderly development of the site and the existing permitted uses on adjacent blocks. So basically, it has to be in keeping with the appropriate and orderly development of the district. The second one is that the location, nature, and height of the buildings, walls, and fences, and the nature and extent of the landscaping on the site are such that the use will not conflict with the existing permitted uses on adjacent blocks and will not hinder or discourage the appropriate development use of adjacent land and buildings. So this is focusing on buildings, walls, fences, and landscaping, and confirming that the nature of those things that are proposed in connection with a special permit are not going to conflict with existing permitted uses and the appropriate development of the area. The third is that operations in connection with any special use are not going to be more objectionable to nearby properties by reason of noise, fumes, vibration, or other characteristics in Article 4, that's your performance standards. Then would be the operations of any permitted use not requiring a special permit. So is the special use going to create noise, fumes, vibration, or other similar annoyances that would be, that would be more than would be allowed by a permitted use, not requiring a special permit. Fourth is that the parking areas will be of adequate size for the particular use and properly located and suitably screened from adjoining residential uses. That the entrance and exit drives are laid out to achieve maximum safety, and the uses will not cause unreasonable traffic congestion or create a traffic hazard. So there we're focused on parking and traffic and safety issues. The next one is that uses, buildings, and operations will be accessible for emergency services and appropriately located for water, sewer, and other infrastructure requirements. So, is an ambulance able to get there? Is a fire truck able to get to the site to properly deploy their services? And is there appropriate water, sewer, and other utilities servicing the site? And lastly, the use will comply with other regulations in the code and will be compatible with the recommendations in the city's comprehensive plan and the LWRP, which is the local waterfront revitalization program. So the use has to be consistent with the city's comprehensive plan and all other provisions of the code. So those are the general standards. Those are the standards that apply to every single special use permit in the city. Then there are specific standards. There's a lot of these, there's a lot of specific standards in your code for various uses. Not every single special use permit has a set of specific standards. Some of them just rely on the general standards. I pulled just one example out of your code for bed and breakfast. This is at 223-24.4 as just an example of standards that the City Council felt were appropriate for making sure that a bed and breakfast in particular is not going to have an adverse impact in the district in which it's proposed. So as long as an applicant can demonstrate that they meet these standards, then the special use permit would have to be issued.
Question,
And-
just
yeah.
in terms of, like, when we talk about SECRA, some of those adverse impacts are pretty well delineated. In cases like this, what sets the criteria for what an adverse impact is, what rises to that level?
Right, so, I mean, if we go back and look at the general standards, we see, let's see, so parking, for example, parking and traffic. So if you go to D, that overlaps with SECRA, right? Because
Yeah.
when you make your SECRA determination, you're making a determination that the proposed special use will not create a significant adverse environmental impact
Yeah.
as it relates to parking or traffic. So
So,
there is some overlap.
I was going to say, to
Yeah.
some degree, they would need to align,
Yeah.
right? Our review and position on special use, as well as our review of SECRA and our findings there.
Yeah, I wouldn't, I think that you would not want to be in a situation where you are saying that there's no significant adverse impact with respect to traffic for a proposed use, traffic congestion, that the roadways, can handle all of the traffic, and, it all meets those tests. But then, a month later, you're finding that you're going to deny a special permit because of traffic impacts, because you find that they don't meet this condition D. That would be a situation that I would
inconsistent.
not recommend that you be in.
Yeah.
Is it possible that with the special permit, the intensity of use issue, where an adverse impact doesn't necessarily rise to the standard of a SECRA, but does not meet the standard of the special use permit.
Right, so I think you're talking about, for SECRA, you have to find that there's there's no significant adverse impact. But I think you're asking, is there some delta between where, maybe it's not significant, but maybe it's an impact that, that would cause you to find that it doesn't meet one of these standards. So I've always thought theoretically, I think that's possible.
Sure.
I've seen cases that say, look, if you make one finding in SECRA, you can't make an opposite finding when if you're going to deny an approval. I think you have to be very careful. It's a very nuanced concept.
Maybe one way to look at these would be as areas of focus, but your criteria for determining whether there's an adverse impact or not should be pretty across the board, whether you're looking at SECRA or whether you're looking at a special use permit. Your criteria for a traffic study or for whether a driveway is laid out safely should be the same. But this is pointing you at certain things and saying, hey, for a bed and breakfast that's in a residential neighborhood, we want the ingress and egress to be safe. We want the parking areas to be screened. But the criteria for impacts should not be too much different from everything else. Otherwise, you'd open yourself up to being accused of being arbitrary and capricious.
I think that's a great way to look at it. That's a great summary. Right, so these were some of the specific standards for bed and breakfasts. Again, some of these are black and white, right? Minimum lot size is 40,000 square feet. Either you meet that or you don't. Others, as we just saw in the general standards, require a little bit more discretion. You're applying your discretion as planning board members to determine whether the applicant has met that standard. It's not as black and white. So, there's off-street parking has to be screened from adjacent residential properties. The lodging provided shall be for periods of less than 2 weeks in duration. So a lot of these end up being conditions of the special permit as well. So what happens if someone wants to establish a bed and breakfast, it's subject to a special permit, they're on a lot of 30,000 square feet instead of 40,000 square feet. That doesn't necessarily mean that they can't get the special permit. They're allowed to seek a variance from the special permit standards in the same way that they would be allowed to seek a variance from setback requirements of the district.
So does that mean their first stop would be ZBA?
Typically, it
They're
would get
always
referred to
they're
the
coming here
zoning
first?
board. They would
Yeah.
come here first and get referred over to the zoning board.
Yep.
So there was a case that went all the way up to the Court of Appeals, which is the highest court in New York, back in 2004, that confirmed, in fact, that the New York State statutes do allow the zoning board authority to grant area variances from special permit standards. So there was a question in the law about whether that was the case or not, and that was resolved, almost 20 years ago at this point. So, we've got just a couple minutes left here. So I don't know if we're going to get to the case law examples, but maybe that'll be a preview for next training session.
Okay.
We can go through some of the case law examples. So when you are making your final determination on a special use permit, both New York State statute and your code allow you to impose reasonable conditions that are directly related to and incidental to the proposed special use permit. One case law example here, these conditions have to relate to the use of the property and not the applicant or the owner. This case that I have cited here, Dexter versus Town Board of the Town of Gates, it's an old case, it's from 1975, but I think the facts of it are kind of interesting. It actually relates to a rezoning. So the applicant asked the town board to rezone a particular piece of property. It was to allow a supermarket, in fact, a Wegmans. Everybody loves Wegmans. So Wegmans petitioned the town board to rezone the property. The town board did rezone the property in response to that petition and imposed a bunch of conditions on the rezoning, including a condition that said the application for the construction of a retail supermarket by Wegman Enterprises, Inc., and related structures shall inure to the benefit of Wegman Enterprises, Inc. only, and for that specific purpose only. So basically, the town board was saying, we'll rezone the property to allow for Wegmans to build a supermarket, but only for so long as that supermarket is a Wegmans. So the rezoning only applied to Wegmans. So that case went up to the Court of Appeals, and they held that condition was improper because it was personal to the Wegmans entity itself and didn't relate to the use of the property. And that goes to the very fundamental principle that zoning deals with the land use and not the person who owns it or occupies it, or the business entity that owns it or occupies it.
So their thinking was that they would save themselves a step of rezoning it back to its previous use if Wegmans disappeared.
Right, I guess they just really liked Wegmans.
Yeah.
And didn't want to allow a, ShopRite or Stop and Shop or anyone else that benefit. So I know we've got not much time left here.
You got 3 minutes.
Okay, 3 minutes. We'll zip through. The other thing that you want to keep in mind when you're considering your final determination, in addition to what conditions you might want to put on a special permit, is the age-old rational basis, substantial evidence standard. So the decision to grant or deny a special permit must have a rational basis supported by substantial evidence in the record. So this standard applies to every single decision that you make, whether it's special permit, site plan, subdivision, any decision. You have to have a rational basis in the record that you can point to.
Can you read that one more time with emphasis? That is really important.
It's so important.
Super duper important.
Because the flip side of that means that if you are making a decision that does not have a rational basis in your record, and the record being the testimony, the documents, everything before you, then your decision is arbitrary and capricious, which will be overturned by a court, which you don't want to happen. So again, I'll read that again if you want. The decision to grant or deny a special permit must have a rational basis supported by substantial evidence in the record. The applicant is the one that has the burden to show compliance with the conditions of the special use permit. And I think that this quote from the Second Department case from 1998 is a helpful one. It says, while a property owner is not entitled to a special use permit merely for the asking, once it is shown that the contemplated use is in conformance with the conditions imposed, those are those general conditions and the specific conditions that we spoke about, the special use permit must be granted unless there are reasonable grounds for its denial supported by substantial evidence. So I think that's a really powerful statement and speaks to the standard that applies to your decisions.
Great. Fantastic.
So for next time, we'll go through some examples of cases and fact patterns.
Excited. Can't wait.
Yeah.
Fact patterns. Awesome. All right. Thank you, Jennifer.